Hi guys, this is an issue that's likely to split UK politics in the coming years, the ECHR. Recently, Prime Minister Keir Starmer reinstated his government's commitment to the Convention and the Court, while some Conservatives and of course Reform UK want Britain out of it. To clear up some of the misconceptions and to get a better understanding of what the ECHR is, I spoke to the author of the book Fixing Broken Britain, Alun Drake.
Yeah. Hi, Max. Very happy to be here. My name is Alun Drake. I work for the Council of Europe in Strasbourg. I'm a former television journalist from the UK, and I've been working at the Council for 28 years, promoting its image because it's not as well known as the European Union. So I'm here to talk today about the European Convention on Human Rights. And that's a wonderful instrument that I'm going to explain a bit about to your viewers in a moment.
Yes, because we're hearing a lot about it in the media. But, for example, the Conservatives have recently talked about leaving the convention. Keir Starmer recently came out and said that he's fully on board with remaining part of the convention. So can you tell us a little bit about the convention itself and why it's so special?
The European Convention on Human Rights is an international treaty that was signed by 12 countries, including Ireland and the UK, in November 1950 in Rome. And it was inspired by the Universal Declaration of Human Rights from the United Nations 2 years earlier. And it covers a full range of human rights and fundamental freedoms, everything from the right to life and the right not to be tortured, to the right to marry, the right to have property, the right to have freedom of conscience and religion, the right of freedom of expression. So it's a very comprehensive list of human rights that are protected. But what makes it really special is that it set up later a mechanism to enforce those rights, because the UN Declaration was just a statement of rights. It didn't have any enforcement mechanism. The great thing about the convention is that it gave birth to the Court of Human Rights, which means that any individual in Europe who's a member of a Council of Europe member state can take their government to court in Strasbourg. And also not only individuals, but groups of individuals and indeed member states. So, for example, Ireland took the UK to court in 1978 over interrogation techniques during the Troubles, and the UK was found wanting, and it had to change its interrogation methods. But this kind of protection, this double layer of human rights protection, doesn't exist anywhere else in the world. It's unique to Europe. And this means that, for example, if you put it in a different context of consumer protection, imagine that you bought a laptop from Apple and it went wrong on day one. You tried to get a refund. Apple said nothing was wrong with it. So you appealed over the head of Apple to an international federation of computer manufacturers who found in your favor and told Apple to refund your money, to give you another free replacement laptop. That's a kind of example from the world of consumer protection, but that's the level of protection that we have as European citizens, which doesn't exist in America, it doesn't exist in Asia, it doesn't exist in Africa, it only exists in Europe. And it's something revolutionary in legal terms, the idea of supranational justice, that a court in a different country can tell your government to give you justice. This is something absolutely unique. And if you ask me, why is it only in Europe? The only answer I can think of is that we had the terrible Second World War in Europe that destroyed everything. And it really opened people's minds to the idea of ceding a bit of national sovereignty for the sake of human rights and democracy and justice. And so it didn't happen in any other continent, probably because no other continent was as devastated. And there was not this open-mindedness that there was in Europe in the post-war period.
But for example, critics would say in Britain in particular that, well, we don't need the European Convention on Human Rights because we have already the Supreme Court who will protect people's rights. How would you respond to that?
Well, every country in Europe, including the Scandinavian countries, which are seen as paragons of democracy and human rights, have been found wanting at some time or another in the court in Strasbourg. So there's no, of course, we all expect that our governments are not going to abuse our human rights. We have full trust and faith in our governments. But unfortunately, there have been many instances in each country in Europe, in each of the 46 members of the Council of Europe, where that hasn't been the case. So you can have as much faith as you like in your country, but sometime or other, there will be someone somewhere whose rights are abused by that government. So it's not true that you don't need a court, because even a perfect government or a near perfect government will make mistakes.
How does one apply to to have their human rights protected? Is there a procedure, or what is it?
Yes, there are certain conditions. Anyone in principle can apply, but they have to go. For example, the first thing is that their case has to have some relevance to the Convention on Human Rights. It has to apply to one of those rights. The second thing is that they have to, what the lawyers call, they have to exhausted the domestic legal remedy. That's a very grand phrase, but what it basically means is that you have to go through the entire legal system in your own country. In my case, the UK, you have to go to the Supreme Court and you have to lose in the Supreme Court. And only then can you go to Strasbourg. And the third condition is that you have to do that within 4 months of losing in the Supreme Court. So there's a time limit. So you have to react quite quickly after having lost. After 4 months, that option is no longer open to you.
I think it's good that you're clarifying that misconception I think many people have of that it's just people going directly to the European Court of Human Rights to resolve a particular issue. So you were saying about how the court enforces things. So in what way can the court enforce a ruling on a member state?
Like any court, there has to be an enforcement mechanism. In a criminal court in the UK or in Ireland, when the judge says to someone, I sentence you to 10 years in prison, there has to be a police officer or Garda officer to take that person to prison. There have to be prison officers to look after that prisoner. And it's no different with the Court of Human Rights. There has to be an enforcement backup mechanism to make sure that once the court delivers a judgment, there has to be an enforcement follow-up mechanism to make sure that the member state actually does what the court tells it to do. So the body that does that is the Committee of Ministers of the Council of Europe. These are actually ambassadors, so we could call it the Committee of Ambassadors of the Council of Europe. They represent the foreign ministers of the member states, but of course the foreign ministers are very busy with day-to-day foreign affairs. So the ambassadors who live in Strasbourg all the time, they're the ones whose job is to follow up the judgments of the Court of Human Rights and to make sure that they are executed, as they call them. So it's the kind of execution of judgments is the technical term, and they make sure that countries do what they're supposed to do. And in the vast majority of cases, this happens. But the tricky question comes, what happens when a country doesn't follow a ruling of the Court of Human Rights? Because that casts into doubt the credibility of the court system. Fortunately, it doesn't happen very often, but sometimes there can be some tricky cases. An ongoing case that's happening right now, there was a Turkish businessman and political activist called Osman Kavala, who was imprisoned by Turkey, and he brought a case to Strasbourg under the section about the right to a fair trial, and the court ordered his release, which Turkey didn't do, and then there was a second court ruling saying you didn't release him as we ordered you to do in the first ruling. And now it's in the hands of our Committee of Ministers, or as I call them, the Committee of Ambassadors. And they are engaging in diplomatic dialogue with the Turkish authorities to move this case along so that this man, Mr. Kavala, is in fact released from prison. Now, the question I often get asked is what happens ultimately if a member state does not comply with those rulings? And unfortunately, the nuclear option at the end of the road, once all the diplomatic maneuverings and machinations come to an end, is that country would have to be expelled from the Council of Europe.
And we saw that recently with Russia.
Russia was expelled because of the invasion of Ukraine, which of course was completely incoherent with its undertakings to the Council of Europe and the Convention on Human Rights. In the case of Turkey, we are ongoing, or the ambassadors are ongoing in their negotiations. And it's never happened that a country has been expelled because it didn't comply with the Human Rights Court. So we're hoping very much that there will come a point where Turkey will will respect the judgment of the Court of Human Rights. But that's one example. And in the vast majority of cases, these are resolved eventually. In the UK, for example, there was prisoner voting rights, if you remember that case, very controversial. But in the end, there was a resolution, there was an accord, and there was an agreement between the UK and the Council of Europe, or the Court of Human Rights, and that issue was resolved satisfactorily for both sides. So there is a mechanism, and in vast majority of cases, it works.
You've mentioned the Council of Europe a number of times here. Can you explain, maybe for some people who don't know, the difference between the Council of Europe and the European Union? Because I think that's a misconception many people have.
Well, the Council of Europe is an organization of 46 member states, used to be 47 when Russia was a member, and the European Union is an organization of 27 states. So we have about 19 more countries than the European Union, and many of our members are countries like Turkey, Ukraine, the UK, which are not members of the EU, but they are members of the Council of Europe. So every member of the European Union is a member of the Council of Europe, because you can't become a member of the EU until you've proved your democratic and human rights credentials at the Council of Europe. But there are a number of countries that would like to become EU members, like Moldova, Ukraine, Georgia, Armenia, etc., that are in the Council of Europe, but not in the European Union. So the fact that we had Brexit proved to a lot of British people, I guess, that we are still members of the Council of Europe, since we are still hearing about the Court of Human Rights, the Convention of Human Rights. So I hope that people realize now, in the UK at least, that the Council of Europe and the European Union are two different things, because Britain is a member of the Council of Europe still, but it's not anymore a member of the EU. But the Council of Europe is the parent organization of the Court of Human Rights and the Convention of Human Rights, if you like.
Do you see more countries joining the Council of Europe in the future?
It's a good question. There are not many more potential members, it has to be said. The only countries that are not members are Russia, Belarus, which is excluded because it still practices the death penalty, and it's not a democracy, and it helps Russia with the war against Ukraine. Kosovo has applied to join, but that is again controversial, because Kosovo is not fully recognized by all the members of the United Nations. So that's pending. And then, of course, there's the Holy See, what we call the Holy See, what most people would know as the Vatican. The Vatican is an observer state, but it's not a member state. And so we have a number of observer states, including United States, Canada, and Mexico. So it's quite a broad organization, but there's not much scope for expansion. I guess Kosovo is the most likely extra member. So there's not much more scope. We'll probably go up to 47 members one day with Kosovo, but I don't think we'll expand beyond that.
So just returning to Britain for a moment, and maybe in the media, where we hear a lot about the European Convention on Human Rights and the court, and there's a lot of talk about unelected judges. Can you debunk that myth?
Absolutely. Well, it's very funny, really, because first of all, they are elected. Every judge that is elected to the European Court of Human Rights has to be elected by our Parliamentary Assembly. Now, the Parliamentary Assembly of the Council of Europe is different from the Parliament of the European Union, in the sense that it's made up of delegations from national parliaments. So, in fact, a delegation from Westminster, composed both of MPs from the House of Commons and the House of Lords, and members of the House of Lords, they come to Strasbourg and they take part in those elections. And when I say elections, the member state has to propose the judges itself. So they have to propose 3 names, one of which, of course, has to be a woman. At least one of the 3 has to be a woman. And then it's up to the Parliamentary Assembly of the Council of Europe, which includes British MPs and British members of the House of Lords, to elect those judges. So it's completely wrong to say those judges are not elected. And not only is it wrong, but it's rather ironic, because judges are not elected in the UK the last time I looked. And I don't know if the critics of the Court of Human Rights are lobbying, in effect, for judges to be elected in the UK, because that would be quite ironic, wouldn't it, if they are actually having double standards and saying that we should have elected judges, but not in the UK.
But what about this critique that it's a foreign court? So Rishi Sunak, the former prime minister, in the House of Commons, described it as a foreign court. Why did he describe it as a foreign court, and why is it not a foreign court?
Well, literally, of course, it is a court in a foreign country. So it's located in Strasbourg, which is on the border with Germany. And the reason it's in this particular city is because Alsace, the region in which we're located, was a bone of contention between Germany and France for about 100 years, and there were numerous wars, and it changed hands. So it's a symbol of reconciliation between Germany and France. We're in Strasbourg. So that may be a literal reason to call it a foreign court. In fact, it's an international court. It's the same status as the International Criminal Court in The Hague, or the World Court, also in The Hague, or any other court, really, that's an international court. The Britain and the UK had a huge role in setting up this court. You may remember that it was mostly British lawyers that set up the Convention on Human Rights and the court. David Maxwell Fyfe was a leading light. Winston Churchill gave it his blessing. There are many British lawyers at the court, and of course, every British case has to be heard with a member of the panel of judges has to come from the UK. And the final irony is that the very building that the court is located in, which is a very beautiful modern building, was designed by Sir Richard Rogers, a British architect. So Britain has a big stake in this court from the very beginning, a big investment. And one thing I often think of is, if the court moved to London, would they still consider it to be a foreign court? And by the same token, do the French think it's a foreign court because it's based in France? I think this is a kind of term of abuse, a cheap shot, really. But it's certainly no more a foreign court than any other international court to which the UK has signed up.
Have there been many cases sent to the court from the United Kingdom throughout its history?
In fact, the UK has the lowest number of applications per head of population than any other country in the Council of Europe. So I think it's 3 applications for every million inhabitants, which is very low. So, for example, last year, 2023, there were 38,000 applications in total from all over Europe, of which only 176 were from the UK, of which 3 came down to judgments, of which 1 was a violation. So only 1 British violation of the Convention on Human Rights from 38,000 applications in the whole of Europe. So it's minimal. So in fact, the UK has a very good record at the Court of Human Rights. First of all, not many applications, and secondly, not many violations either. So the UK is a good pupil, if you like.
And which is ironic, because we're hearing more and more about political parties in Britain wanting to leave the European Convention on Human Rights. And I've criticized the term as well. You don't leave the convention, you just don't apply the convention. But so what are some of the risks if maybe someone like Farage, Reform UK, do get into power and they have a referendum on leaving the convention, and the UK does decide to leave the convention? What are some of the risks involved?
Well, I think there are many risks, but there are 3 main risks. The first one is the threat that would pose to the Good Friday Agreement, because the Good Friday Agreement, baked into that, has the European Convention on Human Rights. So if we were to pull out of the European Convention on Human Rights, that would unravel the Good Friday Agreement with the attendant risk of intersectarian strife in Northern Ireland. And I firmly believe that the peace in Northern Ireland was one of the great achievements of the Tony Blair government. And I think that would be a huge tragedy to plunge Northern Ireland back into uncertainty and strife. So that would be risk number 1. Risk number 2 would be a similar risk to the trade and cooperation agreement with the European Union. In other words, the Brexit withdrawal agreement, because the Convention on Human Rights is also baked into that. So that would mean that the whole of Brexit would be at risk of coming apart, because we would not be honouring our commitment under the Trade and Cooperation Agreement. So that's number two. But I think even greater, perhaps, than both of those risks would be the hit that would give to Britain's international credibility and our soft power, because we are supposed to be the mother of parliaments, the respecter of human rights. We have a seat on the Security Council of the United Nations. And we would be joining in some very bad company. We'd be joining Belarus, we'd be joining Russia as the only major European countries outside the convention. And further, we might actually be encouraging other countries to leave the convention. And by the way, if you leave the convention, it's tantamount to leaving the Council of Europe, because you cannot be a member of the Council of Europe unless you sign up to the Convention on Human Rights. So maybe some countries that don't have such a good reputation on human rights as the UK would say, look at the UK, they're leaving the convention. Maybe we should do the same thing. Why should we bother if one of the founder nations is pulling out? So it could bring the whole house down of the Council of Europe. But more than anything else, it would undermine the credibility of the UK as a human rights respecting country.
But for example, people like Suella Braverman have said in the past that it's necessary to leave the convention in order to deal with the so-called small boats that are crossing the channel. How would you respond to that?
Well, the problem is that the Human Rights Convention is just one of many conventions that protect the rights of refugees and asylum seekers. There's the Refugee Convention, for example, which has nothing to do with the Council of Europe. I believe it's a United Nations convention. We've signed up to that. Are we going to breach that as well? So just coming out of the ECHR would not be enough anyway to deal with the small boats and the people crossing the channel. You'd have to go a lot further, and so it wouldn't achieve the ends for which the advocates are arguing.
So looking into the future, what are some of the challenges we're going to see for the European Convention on Human Rights and the court itself, for example, in relation to, for example, new technologies like artificial intelligence or climate change? Can you tell us a bit about some of these challenges?
We're already beginning to see climate change come up at the court. I don't know if you've heard of the Swiss seniors case, which was recently at the court, but what happened was a group of women from Switzerland over the age of 64, hence the description of them as seniors, brought a case against Switzerland to the court, saying that Switzerland had not to combat climate change and was therefore potentially threatening their health and their well-being, as well, of course, as that of their children and grandchildren. And the court agreed with them, even though it threw out some similar cases on the same day. It actually agreed with them. So in theory, Switzerland has to go back now and look at its climate change policies and see if it can improve them. So that's one example. The environment and climate change are increasingly being tested at the court. As regarding artificial intelligence, this is such a fast-moving area, and the Council of Europe has actually brought out a convention on artificial intelligence recently, that I can't imagine that artificial intelligence won't become in the future a factor at the Court of Human Rights. We don't yet know in which ways, but it surely could come to test the boundaries of the Human Rights Convention in the future. And there's another issue which is not yet resolved, and this is the issue of the European Union as a legal entity and as a human rights actor. Because at the moment, if your human rights are abused by an official acting for the European Union, for example, let's take the Frontex border force. They interact a lot with refugees, asylum seekers, people coming from trying to get into the EU. Imagine that somebody's human rights were abused by a member of that Frontex group in a hypothetical situation. How would those people get justice, or where would they go for justice? Because those people are not employed by a member state. They're not the government official. They're the officials of a supranational body called the European Union. So there's a kind of grey area there. And so the Council of Europe has for many years been negotiating with the European Union to say to the European Union, why don't you sign up to the Convention on Human Rights? And in other words, adopt a legal person, what they call a legal personality. So the European Union in that case would send a judge to Strasbourg to sit along the British judge or the Irish judge. There'd be a judge from the EU. And if anyone's human rights were abused by the European Union, by an official of the European Union, there would be a mechanism there of seeking redress. In a similar way, if you're a member of a country that belongs to the EU, and you're also in a, let's say, let's take Italy, for example, or Ireland, and your human rights are abused, you can, in theory, decide to choose between the European Convention on Human Rights, which is the Strasbourg Court, or the EU a number of years ago brought out a Charter of Human Rights. And in theory, the court in Luxembourg, the EU court, might one day develop a competence in human rights. So there could be a kind of competition in the future, or at least a choice between two alternative human rights paths to take. And so if the EU were to join the Council of Europe in terms of the convention, if it were to sign up to the Convention on Human Rights, that would resolve that issue of a sort of possible duplication. Not that that exists at the moment, but it's a potential problem that could exist in the future. So there is kind of a negotiation ongoing to get the European Union to sign up to the Convention on Human Rights, to send a judge to Strasbourg, and to be fully integrated into the human rights protection mechanism of the Council of Europe and the Court of Human Rights. And by the way, one of the interesting things about the convention is that it's not only open to people from Council of Europe member states. That's to say people like you and me, Max. But imagine there's a case of an American or an Australian backpacker who has too much to drink and gets too merry and is maybe beaten up by a policeman on a beach in a sunny member state of the Council of Europe, and is then has a case against a member state, because if you're abused by an official of a member state, you can take your case to Strasbourg. If you're beaten up by a bouncer or doorman at a nightclub, that won't work because that's a private entity, a company. But if you're assaulted by someone working for a state, then you have a prima facie case. But the bad news is that you'd have to then go through the legal system of whatever country it was that you were in. And that might take a few years. But if you, like everyone else, got to the Supreme Court in that country and lost, you as an American or an Australian or any other nationality could take your case from there to Strasbourg. So that's not many people know that, as Michael Caine used to say.
And well, that's why it's so important that it's protected and that so many countries like the United Kingdom remain part of it. So it's been fascinating talking to you today about this, Alan. Is there anything you'd like to tell us before we finish? Actually, I must say thank you for sending this to me. Can you tell us a little bit about the book before we go?
Yes, well, I'm a British citizen. I've been living in France for 28 years, and for me, Brexit was kind of a heavy blow. To be deprived of my membership of the European Union as a European citizen hurt very much. So as a way of getting this out of my system, of sort of catharsis or whatever, therapy you might call it, I wrote this book on what's wrong with the UK. And it deals with things like the failings of our democracy, the fact that it's a very old democracy, hasn't been modernized, the class system, as evidenced with the private schools versus state schools issue, and then the education system in a broader sense of what should we be teaching in our schools in the UK, perhaps citizenship and kind of critical thinking and different subjects. So it deals with a wide range of issues about what makes the UK a bit different from other countries, and what, if you really wanted to fix Britain, what would you do? So I want to look beneath the day-to-day politicking and look at the fundamentals of the UK, the reasons that we arrived at Brexit, if you like, what caused such discontent, how come the country became so dysfunctional. And that's what the book is all about, really. It's looking underneath the bonnet and saying what is wrong with the UK and what do we do to fix it.
I'll leave a link in the description of this video so that people can check out the book. I recommend they do that. Alan, it's been a pleasure. Thank you so much for speaking with me today. And I hope to see you again in the future.
That would be great. It's been a real pleasure, Max. Thank you very much for having me.